Now, we left off at the last hour saying that for Article 2, judicial notice is important, and the distinction between the way judicial notice is handled in a civil versus a criminal case is very important. Be sure to be aware of that. Next comes Article 3, and the critical thing out of Article 3 is presumptions. And the section that you want to take a look at there is 301. And let me first tell you about presumptions, and then you can make sense out of 301. A presumption is used in situations where, for example, I have mailed a letter to you, and the question is, did you receive it? Well, the postal system in the United States is so good that the odds are very good that you actually receive the letter. You may not have. It's 1 out of 50,000 or less, 100,000 or something. You might not have received it. But generally speaking, the postal system is so good that you most likely received it. And so because it is so likely that you received it, we have a presumption in the legal system that if I properly mailed the letter to you, that we will presume that you received it. And that means that if you didn't receive it, you got to do something. Okay? So the presumption favors me that you received it, and if you're saying you didn't receive it, you got to do something. We'll talk about what you can do in just a minute. If people are presumed to have not committed suicide, if the insurance company wants to not pay a life insurance policy on the claim that the person committed suicide, well, people generally don't commit suicide. I mean, it's very unusual. And so there's a presumption that people don't commit suicide. And if the insurance company is going to try to prove they did commit suicide, then they got to do something. So that's how these presumptions are used in situations where the outcome is very likely true, and so likely that we'll start out assuming it's true, presuming it's true, and then decide who doesn't like it's got to do something about it. Now, what can they do about it? And the answer is that there are two things they can do about it, and what they can do depends on the rule in their jurisdiction. And there are two set of rules. Some jurisdictions follow one rule, some follow another. One set of rules says that if there's a presumption that goes against you, presumption that you received the letter, that you can offer credible evidence that you did not receive it. Credible evidence means just enough evidence so that it would be rational for a jury to believe you didn't receive it. For example, you might take the stand and say, I just didn't get it. I love my mail. It's the best part of my day. And I just didn't get it. Well, the jury might believe that. So that's credible evidence that you didn't get it. And they may or may not believe it, but you presented enough evidence so it would be rational for the jury to believe you didn't get it. So if there's a presumption against you, then in some jurisdictions what you can do is you can make that presumption completely disappear. How do you make that presumption disappear? You make it disappear by offering credible evidence contrary to the presumption. Take the stand and say, I didn't get it. In that case, if you've made the presumption disappear, when the court gives the final instructions to the jury, the court will not say anything to the jury about a presumption that they did or didn't get the letter. Instead, the jury simply hears you saying, hears me saying, I mailed it, and you're saying you didn't get it. And they can decide what they want to about that. But the presumption disappears as soon as you present credible evidence contrary to the presumption, it's gone. And that's one way that presumptions are handled. A lot of states do it exactly that way. The federal rules do it exactly that way. Now, there is another way that presumptions can be handled, and that is that once the presumption has been created against you, you receive the letter. The defendant, the deceased did not commit suicide. So once the presumption has been created, now in order to create the presumption, you do understand, obviously, I have to establish certain base facts. If I want a presumption that you received the letter, I got to establish that I mailed it and it had the right address on it, and had a stamp on it, and that kind of stuff. But that's common sense, you know that. But once you have the presumption against you, in some jurisdictions you can make that presumption disappear in the way I told you. In other jurisdictions, once the presumption is against you, you can never, ever make it disappear. There's nothing you can do to make it disappear. Instead, you are stuck with it, and you have to overcome. You have to win in spite of the presumption. You have to present the preponderance of the evidence so that the jury will believe you in spite of the presumption. Example, I say I sent a large check. I sent some cash to the bank, an envelope, and I mailed it. Now, since it was mailed, there's a presumption that it was received. And let's suppose that we're in each of the two types of jurisdictions. In the jurisdictions where I can make the presumption disappear, where the bank can make it disappear, the bank will say, gee, we didn't get it. So the presumption has disappeared, and now the court will hear me saying I mailed it, and the bank saying I didn't get it. But suppose you're in a jurisdiction where once I have created the presumption against the bank, they cannot make it disappear. They have to overcome the presumption with the preponderance of the evidence. Well, in that case, the way they would overcome the presumption is the bank might say, look, we get a lot of cash in the mail. And because of that, we have standard procedures to take precautions against it being stolen in the bank. All the mail is opened in a mail room. And first of all, we log in all the mail in a log before we open it. Then we open all the mail in the mail room. And in the mail room, it's a one-way mirror so that the supervisor can look in and see what people are doing at any time. There's also a camera that's operating as on full time when people are in the mail room opening the mail. And so we have been through our logs, we've been through our camera, and we say we didn't receive it. And you're welcome to look at this stuff if you want to. Tell the other side that. And so you can see then that probably the bank in that case has overcome the presumption that they got it with the preponderance of the evidence. But in that case, at the end of the trial, the jury will be told, ladies and gentlemen, in this state, if you believe Emerson mailed the letter, you must conclude that the bank got it, because the presumption is that they got it, unless the bank has convinced you with the preponderance of the evidence that they didn't get it. Okay, then that's how presumptions work in those jurisdictions. Now, when in a jurisdiction where you can make the presumption disappear, we say, I said to you just now, you make it disappear by presenting credible evidence to the contrary. And the way that it's formally said is you say the presumption disappears if you go forward with or present credible evidence to the contrary. Go forward with or present credible evidence. Then the presumption disappears. In jurisdictions where you cannot make the presumption disappear, it says that you have the burden of persuasion. Okay? The bank has to persuade the jury that they did not get the letter. The burden of persuasion. Now, let's look at 301 and see how the federal courts, and one more thing about these before we look at 301, two more things I need to tell you. We know some jurisdictions, the party against whom the presumption works has the burden of going forward with evidence to make the presumption disappear. In other jurisdictions, they will have the burden of persuasion to persuade the jury that they didn't happen in spite of the presumption. Now, the thing I need to tell you is that there's some jurisdictions like California, we have both types of presumptions in California. We say that you shouldn't treat all presumptions the same way because the presumptions are based on different reasons. The reason that we presume that people receive letters when they were mailed is because it is by far more likely that they did receive the letter. The reason we say that we presume people don't commit suicide is because that's a public policy position. Public policy says we're going to presume that people didn't commit suicide, and anybody who claims they did commit suicide, they got the burden of proof. It's a matter of public policy. Whereas in the case of the letter being mailed, it's really a question of probabilities rather than public policy. Most likely you got the letter. Now, in California, we have both types of presumptions. And we say that presumptions which are based on probabilities, like mail, that those presumptions simply, the person against whom the presumption is made has a burden of going forward with credible evidence, and then the presumption disappears. Burden of going forward if it's a presumption based on probabilities. But if it is a presumption based on public policy, like people don't commit suicide, then the person who claims they did commit suicide, they have the burden of persuasion. So we have both types of presumptions in California. This means if you look at the California codes, everywhere there's a presumption in the California code, right there with the presumption you will see a statement saying which type of presumption it is. It's either a presumption affecting the burden of proof or a presumption affecting the burden of going forward, one or the other. Now, let's look at 301 and let's see which of these two systems is adopted by the federal rules. Federal rules at 301 says, in all actions and proceedings not otherwise provided for by act of Congress or by these rules, a presumption imposes on the party against whom it is directed the burden of going forward. Okay? That's the key language. So under the federal rules, as soon as you go forward with, as soon as you present believable evidence that the presumption didn't happen, then the presumption disappears and the jury hears both sides, but they don't hear an instruction regarding presumptions. So the federal rules follow the burden of going forward rule. Finally, I need to tell you about 302. 302 is important and could easily be tested. And 302 says that if you are in federal court based on diversity, so that you're using state law but federal procedure, that 302 says use the rule of presumption of the state whose substantive law you are using. Once again, if you're in federal court based on diversity using somebody's state substantive law, and the state whose substantive law you're using, use that state's presumption rule. That's what 302 says. That wasn't so hard. This brings us into Article 4. Article 4 is about relevance. Evidence is relevant if it tends to prove a fact of consequence. And we know from our early discussion what a fact of consequence is. Any fact such that if you believe that fact is true, then you're more likely to believe the element has been satisfied. In the case of our burglary here, these were facts of consequence. Fact 1, fact 2, fact 3 were all facts of consequence. Now, so Article 4 is about relevance. And there's a bunch of critical sections here in Article 4, and I'm going to put them here on the board on the side, just so we can talk about them. Some really important ones. First of all, Article 4, there is 401. 401, please take a moment and read 401 right now. Now you see what 401 says. 401 defines relevant evidence. And it says relevant evidence is any evidence that has any tendency to prove a fact of consequence. Okay, that's fine. Next we go to 402. Now 402 is a very important rule. It is the basic rule of evidence. What 402 says is that all relevant evidence is admissible, and only evidence is admissible, relevant evidence is admissible, unless something else is wrong with it. Let me say that again to make it clear. All relevant evidence is admissible unless something else is wrong with it, such as hearsay. All relevant evidence is admissible unless there's something else wrong with it. And only relevant evidence is admissible. Please read 402. All relevant evidence is admissible unless there's something else wrong with it, and only relevant evidence is admissible. That's 402. So 402 really is the first big cut in the law of evidence. If you want to know what stuff is admissible and what stuff is not admissible at the trial, this is the first big cut. It says everything that's relevant, bring it in unless there's something wrong with it. If it's not relevant, leave it out. So that's the first big cut in terms of all the rest of the evidence in the world and the evidence that might get admitted at this trial. 402, big deal. I mean, you don't think about this so much, but you need this to sort of, make the structure sound. That's 402. 403. 403 is the rule that says evidence which is substantially more prejudicial than probative is not admitted, even if it's logically relevant. That if it's unfairly prejudicial, don't admit it even though it's relevant. So this is we often call it legally relevant. Please notice that the rule itself, you read 403, and it doesn't use the language legally relevant. What it says is that even though the evidence is logically relevant, that if it is, that it will not be admitted if it's substantially more prejudicial than probative. Let me give you an example. My favorite example, there was a case where a person's arm was run over by a freight train and severed. The person survived, and now they're suing the train company, saying that the train company acted negligently in running over the person's arm. One day at the trial of plaintiff versus the railroad company, the plaintiff's lawyer comes to court with a long brown paper sack. And in this long brown paper sack, he, at the right moment, says, and my client's arm was severed by the train, and here it is. Brings out the severed arm. A little bit of centrifugal force there to put some blood on the jury. And says to the jury, now you see this arm here. You look here where the shoulder used to be, and you can see the train tracks. And that's how we know the train severed my client's arm. Now, that evidence that the train ran over, severed the person's arm, that is relevant because it tends to prove a fact of consequence. It tends to at least, prove causation, prove that the train severed the arm. So showing that the client, the jury, the arm and the train tracks and so forth, that the plaintiff is establishing a fact of consequence. And this has some tendency to establish that. So the arm, the severed arm, showing that to the jury is logically relevant because it has some tendency to prove a fact of consequence. So showing the jury the severed arm is logically relevant, but don't you agree that the jury really is going to misuse that information? They're not going to use that to prove that the train severed the person's arm. They probably already know the train ran over the arm from all kinds of other evidence. What they're really going to use that for is sympathy. And that's not supposed to be a part of the proceeding. And so the jury is far more likely to misuse that information than they are to use it for its alleged purpose, to show that the train ran over the arm. So if you know in advance, the jury is far more likely, substantially more likely, to misuse, to use this information wrongfully, use the evidence for the wrong purpose. If you know that's what they're going to do with it, substantially more likely to use it for the wrong purpose than they are to use it for the right purpose, then don't admit it. And that's what 403 is saying. If it's substantially more prejudicial than probative, don't admit it. And we say that it's not legally relevant. Now the question often comes up, do you need to say to the bar examiners for every piece of evidence that you offer, this evidence is logically relevant because it tends to prove some particular element of the cause of action. You identify the element that it tends to prove. So this evidence is logically relevant, and then it is not legally irrelevant because it is not substantially more prejudicial than probative. Do you need to say that every time? Do you need to say every time? It's also not hearsay, and it's not opinion, and it's not illegally obtained, and it's, do you need to say all those things every time? Well, I don't think so. I don't think you need to say all the stuff that the evidence is not. You need to say what the evidence is not if you're in a situation where there's some question as to whether or not it is legally irrelevant, if it's substantially more prejudicial than probative. And so if it's a dispute, of course you need to say something about it. But if there's nothing that's even close to it being that kind of dispute, I don't think you need to say it. Now, so that takes care of relevance, and that's at 403. Next comes 404. 404 is about character evidence. Now, character evidence is, let me do something here and make a little more room. Should have done this earlier. 401 is the basic rule to define relevance. .402 says all relevant evidence is admissible. 403 is the one that talks about evidence being substantially more prejudicial than probative. This brings us to 404, which is character evidence. Now, the basic idea about character evidence is that you cannot use character evidence to prove conduct on a particular occasion. Okay, that's the basic rule. You can't use the fact that this person drives negligently frequently as a habit, in the past drives negligently, and therefore they drove negligently on this occasion. This person, when they leave home in the morning, they frequently run that stop sign at the end of the block where they live. They don't come to a full stop. And since they've done this frequently in the past, can we use that as evidence that they did it on this occasion? And the answer is no. This person has robbed banks before. Can you use that as evidence that they robbed this bank? The answer is no. And so the basic rule is that you cannot use prior conduct to prove conduct on this occasion. Prior conduct is character. So you can't use prior conduct to show conduct on this occasion. That is the basic policy of the character evidence rules. Now, built on top of that basic policy are some exceptions. Let's talk about what those exceptions are. First exception, if we say, first of all, at a civil trial there aren't any exceptions. At a criminal trial we do have some. At a criminal trial, what kind of exceptions might you consider? Well, I said at a civil trial there are no exceptions. There's one. I'll talk about it in just a minute. So we've decided that the basic policy shall be that prior conduct cannot be used to show conduct on this occasion. Now, at common law, that concept wasn't codified. It was part of the case law. And the way we did that at common law is we say prior conduct, which is character evidence, does not do a very good job of proving what somebody did on this occasion. Prior conduct doesn't do a good job of proving what people did on this occasion. But on the other hand, if a jury knows about the prior conduct, they are likely to use it for exactly that purpose. If this person has robbed several other banks and the jury finds out about it, forget it. Guy's off to jail whether he robbed this bank or not. If the jury finds out about other bad things that the defendant has done, they're much more likely to just say, put him away. We don't want him out here in society. And so you don't want the jury to even know about the person's prior conduct if you can help it, because they'll use it. Even though they're told not to use it, they will anyway. People do that. And so prior conduct is substantially more prejudicial than it is probative. Doesn't do a very good job of predicting what the person is going to do on this occasion, and yet it is very prejudicial because the jury won't like the person. So prior conduct at common law was treated as, or character evidence was treated as substantially more prejudicial than probative. Substantially more prejudicial than probative. Now, that's how it was handled in common law. Well, under the federal rules, instead of relying on that general concept that character evidence is substantially more prejudicial than probative, we codified the whole concept. And the codified concept is here in 404. Now, we understand the basic policy of 404. We've said that several times. But what exceptions would make sense to you? What exceptions, particularly at criminal trials? Well, we said that prior conduct is not a good measure of conduct on this occasion, so we're not going to let it in. But what about if you're trying to impeach a witness? If you can establish that this witness has a bad reputation for truthfulness, his community reputation for truthfulness, well, then the community reputation is not a particular occasion when the person didn't tell the truth, but it is the community belief in this person's truthfulness. And so you're taking the person's prior conduct and sort of taking it in a collective form. And we say in this collective form that if the person has a reputation for dishonesty, then you're going to let that in. So if the person has a poor reputation for truthfulness, you let that in on the question of whether or not they're truthful now. And in a way, that's kind of using character evidence to decide whether or not they're telling the truth now. This person in the past has a history of not telling the truth, bad reputation for telling the truth, then I'm asking the jury to believe right now they are not telling the truth either. So in a way, I'm violating the rule that prior conduct can't be used to show conduct on this occasion. So when we're impeaching somebody, we really have an exception to the character evidence rule. We are allowing the reputation. We don't allow specific acts. You can't say this person lied on one occasion over here, and they lied on another occasion over here and over here, so we got 3 occasions, and we're going to tell the jury about each of these 3 occasions where the person lied. You cannot bring in the specific instances of dishonesty, but you can bring in the general reputation for dishonesty. So that's one exception right there. Is when you want to impeach someone, you need an exception. Okay, and that applies to criminal or civil trials. The second one that applies at criminal trials only is, let me suppose that you have been accused of murdering somebody. And turns out that you were walking down a dark alley late at night by yourself. And it also turns out that you are a seventh degree black belt in karate. And it also turns out that you are a Buddhist monk who's been trained in all this stuff. And so now you encounter this person late at night in the alley, and the person attacks you, and you didn't want to hurt the person, but you defended yourself, and unfortunately the person died. And now you're accused of murder. Well, the other person's dead, and you're accused of murder, and there's nobody around to tell the story except you. Okay? So you're going to tell this. So shouldn't you be able to tell the jury, I'm a peaceful person. I don't even walk on ants on the sidewalk. I'm a Buddhist monk. I don't kill things. And therefore I'm asking you to believe that since I'm such a peaceful person, I didn't kill this person. At least I didn't do it with malice. And so in order to allow me to defend myself in that situation, you almost have to let me talk about my prior conduct, my reputation for peacefulness. So you need to let me put that on. But again, you don't let me put on specific examples of my peacefulness. You let me put on my general reputation for peacefulness. So that's one exception, that when I'm trying to defend myself, you need to let me put on my general reputation. Suppose I am an accountant, and I'm accused of embezzling money from the bank. And I want to say to the jury, look, folks, I've been an accountant for many, many years. I've worked at all of these places, Fort Knox and elsewhere. And I've never in all this time ever been accused of trying to steal money. I have a sterling reputation. And so shouldn't I, in my own defense, be able to offer my good character? And the answer is yes. I should be able to offer my good character for peacefulness. I should be able to offer my good character for truthfulness. If it's for, at least I didn't embezzle, didn't steal the stuff, for honesty. And so you sort of have to allow the defendant in a criminal trial to put on their good character. It would be unfair not to let them do that. But if you let the defendant put on his or her good character, the prosecution, of course, can rebut that with reputation of bad character if they can find that. So let's look at 404, character evidence, and see what 404 says, and see if it doesn't say the things we just talked about. 404A. 404A says, evidence of a person's character or trait of character is not admissible for the purpose of proving action in conformity therewith on a particular occasion. So that's the general rule. Except, and you've got three exceptions here. Let's look at these three exceptions. Let's start with number 3. Well, the third exception is character witness. So the evidence of the character of a witness is admissible to impeach. Look at number 1, character of the accused. Now, I'm the accused, and I want to put on my good character. Let's see if the rule is going to let me put on my good character. Now, I don't want to put my good character on in the form of each of the good things I've done all my life. I have to do it collectively in terms of my reputation. But let's go ahead. It says, this is 404A1. 404A1 says, character of the accused. Evidence of a pertinent trait of character offered by an accused. I'm peaceful. I don't steal. Okay? Or by the prosecution to rebut it. If I open the door, they can rebut. Or if evidence of a trait of character of the victim is offered by the accused. If I say the victim is a violent person and attacked me first, and that's why I want you to know the victim has a reputation for violence, and from that I want you to believe that I was attacked and I defended myself. So Character of the victim is admitted. Evidence of the same trait of character of the accused offered by the prosecution. So if I say the victim is violent, then the prosecution can put on refutation evidence that the victim was peaceful. Okay? So what 404A says is that I can put on evidence that I'm peaceful, but the prosecution gets to say I'm violent. I can put on evidence that the victim is violent, but the prosecution gets to put on evidence that they're peaceful. And that's what 404A1 says. That makes a lot of sense. 404A2 is about the victim. And it says, evidence of a pertinent trait of character of the alleged victim. That's the person the monk killed of the crime offered by the accused. Okay? You're going to let that in. Or by the prosecution to rebut the same for peacefulness of the alleged victim offered by the prosecution in a homicide case to rebut evidence that the alleged victim was the first aggressor. So if I say the victim was the first aggressor, I was in the alley all by myself and they attacked me, the victim is the first aggressor, and I put on evidence that the victim has a reputation for violence. Okay? If I do that, prosecution can rebut, as you might expect. So that's what 404 is saying. The basic rule is 404, character evidence is not admissible to show conduct, okay? But in the case of the character of the accused, or the character of the victim, or the character of a witness who testified that you want to impeach, those are the three exceptions. So we'll just put them down here right now. Character evidence, and we got these three exceptions. One is character of the accused. Other one is character of the victim. And the third one is the character of the witness that you want to impeach. Those are the exceptions. Takes care of 404. Now, takes care of 404A. Everything we said applies to 404A. Now 404B comes in because what 404B is saying is that the rule of 404A is that character evidence is not admissible to show conduct on this occasion. Conduct. You can't use the fact that I run that traffic light all the time to prove I ran it on this occasion. So you can't use prior conduct to show conduct on this occasion. But I should be able to use prior conduct to show something else other than conduct. And for example, I might want to use prior conduct as modus operandi to identify. Person, if a crime was committed with a very unique MO, then there's some evidence that the person who uses that MO is the one who committed the crime. So I can use the prior conduct in that case to identify. Because I use that, remember the conditional admissibility rule that we talked about earlier? We say that 105 is a limited admissibility. 105, limited admissibility, says evidence can be admitted for one purpose but not another. So I can allow this evidence to be admitted to identify someone and still not be used to show propensity to commit crimes. So 404B says there's a whole bunch of other purposes that the evidence might be admitted for. It cannot be admitted to show conduct. But take a look at 404B and look at all the stuff that it can be used for. Would you take a moment and actually read 404B right now, please? I'll stop for 2 minutes while you do that. minute more. Okay, I think we've had a chance to read that, and you see that 404B is the so-called mimic rule. That says there's a whole bunch of stuff that you can admit the evidence for so long as you're not admitting it to show conduct. You can admit it to show motive, opportunity, intent, preparation, plan, knowledge, identity or absence of mistake, or accident, and the main things you have to give notice that you intend to use this code section to the other side. That's what 404 is about. This then brings us to 405. 405 is about if you are going to use character evidence, that is to say, if I'm going to say, I'm going to put on my good character, or I'm going to put on the bad character of the victim. Okay, I'm going to put on character evidence, good or bad, that I cannot do it by putting on specific facts, specific acts. I was honest on these 15 occasions in the past, and therefore I'm an honest person. Can't do it that way. I have to do it by reputation. And so what 405 is telling us just that. 405A says if you're going to put on somebody's character, good or bad, you have to do it by either reputation or opinion. That is, let me suppose that you are at a trial, you are a party to a trial, and I am testifying as to your good character. So when I take the stand, what I will be asked is, Emerson, do you know the reputation of this party for truthfulness? I say, oh yes, I know that reputation for truthfulness. How do you know that reputation for truth? Oh, I've known them for many years. I've done many business deals with them and so forth. That's how I know that reputation for truthfulness. And so then, well, since you know, Emerson, what that reputation for truthfulness is, what is it? And I say, oh, it's sterling. Okay. So you have to lay a foundation and show that I know the reputation, then ask me what it is. At common law, you could ask me about your reputation for truthfulness or your reputation for peacefulness or whatever it is. But you could not at common law ask me for my personal opinion about your truthfulness. You could not ask me about my personal opinion about your peacefulness. Please notice that your reputation in the community is like the community opinion of you, whereas my personal opinion is my personal opinion of you. So reputation is the community opinion. And at common law, I could be asked about your reputation, but not about my personal opinion. Whereas under the federal rules at 405, you see that you can use reputation or opinion. Either one is okay under the federal rules. Only reputation is okay at common law. Now this means that on the bar exam, you get a chance to point this out. A lot of states will follow the common law on this point and allow you to ask about reputation only. Other jurisdictions will follow the federal rules and allow you to ask about reputation or opinion. So use this to pick up extra points. Now, continuing with 405, listen, reputation, opinion, no specific acts. I can't tell you how good I am by listing all my specific acts, and you can't tell the jury how bad I am by listing all my bad acts. You have to do it by reputation or opinion. But there's one exception you need to be aware of. Okay. If I am on the stand, let me say, and I'm offering reputation testimony or my personal opinion about your good character. Okay, I'm on the stand, I'm your character witness, and I say, yes, I know you very well. And then he asks me, what's your record? Do you have an opinion about this person's peacefulness? Oh, yes, I have an opinion about this personal peacefulness. What is your opinion about this personal peacefulness? Oh, this is the most peaceful person I know. Okay. Now, in that situation, there's one more rule you need to be very aware of, and that is that I'm testifying on your behalf, and the other side can ask me about specific acts. Okay, I can't initially testify about specific acts. I have to testify about reputation or opinion. But after I've done that, the other side can ask me and say, Emerson, now, you say you know this person's reputation so well. You say you know you have an opinion that they're so peaceful. And they say, well, now, have you heard that this person shot 4 people on the corner of A and B Street 3 years ago? Got away with it, but they killed 4 people? And I said, no, I didn't know about that particular incident. And the prophet goes on and says, well, you didn't know about that incident. What about this one? Did you know that this person had a knife fight just 2 weeks ago with someone in a gang war? And I said, no, I didn't know about that particular incident either. But, they're a good person. I said, well, now, Mr. Emerson, do you know about this other fight they got into? Oh, well, no, I didn't know about that one either. So you see, the point is that I can be asked about specific acts on cross-examination. I can't volunteer them on direct examination. But on cross-examination, I can be asked about them. And the theory, of course, was that I'm really being asked about these to see how well I really know your reputation for peacefulness. Because if I claim I know your reputation for peacefulness and I didn't know about these things, these incidents that I just told you about, then I don't know it very well. So that was the original idea, is that the prosecution was challenging my knowledge. And that was why the prosecution had to say, well, Mr. Emerson, have you heard about this fight? They can't ask, did you know about it? Because that assumes that it's true. They can ask, have I heard about this fight? Have I heard about this bad thing? And so forth. So I can, so 405A says, if you're going to bring in character evidence, you must bring in character evidence in this form. You must bring it in the form of either reputation or opinion. Okay. But the other side can act on cross-examination, can ask me about specific acts. On cross-exam, they can ask about specific acts. Now, I don't want to go through the entire code in this way, but I'm going through enough of the code so that you really understand that the code regulates the very behavior that we're going to be tested on here. These are the rules that the bar examiners want you to use. 406 is about 406 is about habit. 407. 407 is about subsequent remedial measures. Is about offers to compromise. You know the rule that if I say to you, gee, let's compromise. Well, you can't go to trial and say, Emerson said, let's compromise. Because, it looks like I think I've got a weak case. Courts want people to try to compromise, so you can't use my offer to compromise against me at trial. So these are offers to compromise. $409 is medical. If payment of medical bills. You can't use the fact that I paid someone's medical bills or offered to pay them against me at trial. 410, 411. 411 is about insurance. 410, I forgot what 410 was about. 410 is that if I have a guilty plea and manage to withdraw the guilty plea, you cannot tell the jury about the withdrawn guilty plea. 411 cannot use the fact that I have insurance. You can't tell the jury about that. Use that to show fault. And then the ones from 412 through 415 or 16, those are all about sex crimes, and please read those. So that's how Articles 1, 2, 3, and 4 work. Now, I'm not going to go through 5, 6, 7, 8, 9, 10 in the same way because it would take up too much of our time. Might be a good idea to do it on another, do it separately sometime. But for now, we want to get to some problems. And fortunately, we have gotten through Articles 1, 2, 3, and 4, and that's primarily what this first problem is about. The problem we're going to look at is the one from July 1996. And if you look at the problem from July 96, around page 16 or so of your three-ring binder, that is the question that we're going to do immediately after the break. And that question involves a lot of the stuff that we just talked about. Let's come back